take an opportunity to not only welcome yourselves, but also my colleagues who are on the panel. We have Stanford Kelly, we have Nicole Hickson, and we have Cora Galloway, and they'll give themselves an introduction a little bit later when they're doing their presentations. Can I just ask, first of all, that we're all going to do a presentation this afternoon, and we would ask that any questions you have as we're going through, that you save those until the end. That's because we feel that sometimes questions that are asked as we're going along might well be answered in one of the presentations. So I've given some paper, there's some paper there, and pencils if you feel that you'd like to put your questions down on paper. Okay, so let's get started. Child Justice Bill. What's that all about? What do we want to achieve from this consultation exercise? Well, the consultation itself will provide the government of Montserrat the opportunity to hear the views of people who otherwise wouldn't have an opportunity to comment. So these events will hopefully enable that to happen. It will also give you an opportunity to voice your views and help with the decision-making process. But also we would hope that by the end of the whole consultation exercise and when we finalise the bill, that people will feel a sense of ownership for the document. For us, it's a good way of assessing the impact that the bill will have on the community that it will affect. And I've got to stress that the bill is not in tablets of stones at this stage, so changes can be made. So what's the bill about? The bill is about the judicial processes that we'll put in place for when children come into conflict with the law. And by children, we mean children who are under the age of 18. So if a young person is 18 and a quarter, they will not be dealt with via this particular child justice bill. The bill itself underpins restorative justice approaches, and you'll hear a little bit more about that later, and it aims to protect the rights of children. One of the things that the bill helps us to do is to be quite clear about the minimum age of criminal responsibility. In addition, it focuses on us instituting diversion as a key component of the bill. It enables us to establish a forum called an inquiry, initial inquiry, and it also enables us to have an assessment at a very early stage. What the bill also does is it helps us to widen the sentencing options, and it also helps us to consolidate a whole range of laws. So, why do we need the bill? Well, the bill itself enables us to be more consistent and appropriate in how we deal with children. Whilst we do have a Juvenile Act that's existed since 1982, the bill helps us to come into the 21st century and helps us to use new approaches that help us to work with children who come into conflict with the law more appropriately. It also enables child offenders to be now held more accountable for the actions that they undertake when they commit a crime. The hope is that it will prevent child offenders from committing further offences and thereby promoting prevention or crime prevention. In addition, we want a safer Montserrat going forward. So, as we all know, internationally, Montserrat is known for being a safe community to live in, to visit, to raise your children. So we want to ensure that when children are committing crimes, they are mindful of that agenda. We want to keep Montserrat safe. The bill helps us to set in place clear systems, procedures, and to ensure that all the people that are involved in child justice are well aware of the tasks that they need to complete. It's also consistent with international obligations. And some of those international obligations come under the United Nations Convention of the Rights of Children. And that really pushes us, because there are at least 3, if not more, articles that focus specifically on children who come into conflict with the law. There are other international instruments, and I can kind of share the details of those in terms of the United Nations Guidelines for the Prevention of Juvenile Delinquency that was produced in 1990, and also another set of rules that help us to look at the protection of juveniles deprived of their liberty. So there's quite a lot of instruments out there that we've built into the bill to make sure that we're consistent with international obligations. So the bill itself has 15 parts and 5 schedules. So today what we're going to do is just take you through and pick out key themes of the bill as we go along through the presentations. But before we start, what I'd like to do is just touch on some of the areas regarding ages. So for example, a person under the age of 10 is not criminally responsible for any act or omission. So that means any child that's over 10 will be dealt with by the bill. Under that age, the child, if they commit an offence, they'll be referred to social services. A child under the age of 14 years is not criminally responsible unless it is proved that at the time of doing the act, they knew what they were doing. So there's a burden of proof that has to be put forward. There's also a section that talks about a male person under the age of 12 is presumed to be incapable of having carnal knowledge. Well, the word carnal knowledge is actually in the bill, and I think there's a debate to be had about whether we want to bring it into more useful language that is more likely to be kind of understood. So I just wanted to kind of take you through about the ages of criminal responsibility, just to give you a flavour of what other islands do. Back in 2018, when all of the islands linked to the Organisation of Eastern Caribbean States, when we were all looking at the model bill, this was the age of criminal responsibility for other islands. So I'll just share a few. Age of criminal responsibility in Trinidad and Tobago and Grenada was 7 years. In Belize, it was 9. Here in Montserrat and the Bahamas and Guyana, it's 10 years. And I think there's a discussion to be had about whether we want it to stay at 10, do we want it lower, or do we want it higher? In addition, let's jump forward a little, 13 years for the Dominican Republic. And as you can see, Cuba, their age of criminal responsibility is 16. In Montserrat, we've always had our children at the age of 10 being the age of criminal responsibility. Now, the model bill that came out from the Organisation of Eastern Caribbean States was actually saying that they wanted us to consider 12 years of age. So that's something that I'd like to put out to the audience as to whether they feel Montserrat should increase that age or lower it or just leave it as is. So what's some of the principles that are embedded in the Child Justice Bill? The principles to be applied when dealing with child offenders includes the best interest of the child has to be paramount. We have to keep the child centre stage in our thinking. What we also are encouraged to do within the bill is to ensure that the rights of parents to assist their children when they're going through processes linked with offending. We also want proportionality. One of the things that's quite important is that you have to ensure that the crime that the child has undertaken fits the response that they get. One of the key things is a preference at a very early stage of releasing children from, either a cell or prison. We want to encourage releasing children who have committed offences rather than keeping them incarcerated. But we have to acknowledge that there will be some children who do need to be detained, and you'll hear a bit more about that later. But it's got to be the last resort and for the shortest time possible. And if they are to be placed in a cell or in prison, they have to be separate from adults. And in addition to that, they have to be separated from, we keep females and males separate. So, one of the things that the bill has encouraged us to develop or to establish is what they will call a Child Justice Committee. That committee will be formed for the purposes of carrying out the duties and responsibilities of the bill. And one of the things that's important to note is that that committee will be directed under the following advice, or under the advice of Cabinet through the Governor. So the Governor will be responsible for appointing the persons that are sitting on for the chairperson, and the 2 lay persons, and also a secretary to support the Child Justice Committee. But also the Governor has the responsibility to remove people that he or she might choose to remove from that committee. So what can the Child Justice Committee do? Well, they can release a child to the care of their parents with or without conditions. They can detain children in a place of safety. They can refer to social services, as I mentioned earlier, and they can consider diversion. For us here in Montserrat, diversion is crucial because we want to ensure that we can divert children away from formal court proceedings. So we're going to be obligated through the bill to set up programs to help us to be able to divert. And I've got to say, with my 2 colleagues that are from probation here today, that we do quite a bit of diversion work informally, but the bill enables us to structure it and make it more consistent and coherent. A child can also be referred to a family group conference, which is an opportunity for the child, the parents, the victim of the crime that the child has committed, other members in the community, the probation service, the attorney, for a number of people to gather together to look at what plans need to be made for that child. And at the end of that planning, they have to present the plan to the Child Justice Committee. One of the key things is that if a child doesn't acknowledge responsibility for a crime that they've committed, the Director of Public Prosecutions has the ability to go straight to trial. So they could take the child to the formal court processes. And you'll hear a little bit more about that as we go along. So there are 2 key bits to this whole process. There's pre-charge diversion that would happen outside of this bill. And what that includes is where a child might be observed to have done something and the police are called. The police kind of think, oh, it's minor enough to, just kind of give them a little warning, or indeed say, I expect you to clean Mrs. Smith's windows for the whole month. So they can do something like that, and that will be it done and dusted. There will be no further input. Post-charge would mean that the police officer has determined that the child needs to be apprehended and charged. And there are opportunities within that for diversion. Diversion is quite, as I said earlier, is quite an important part of the bill, and we would hope that diversion could be considered at all steps of the processes, and you'll hear a little bit more about that from my colleagues. There's a forum called an initial inquiry, which will be the first opportunity that the Child Justice Committee will have to informally meet with the child, parents, etc., to look at the crime that's being committed. One of the things that they can make a decision about whether they detain a child or not, but it would have to be a fairly serious crime for them to consider detaining the child. One of my colleagues here is going to move on to looking at assessments, which is again a key part of the whole child justice bill. So I'd welcome Mr. Stanford Kelly to the platform.
Good afternoon to one and all, onlookers worldwide. My name is Stanford Kelly, probation officer within the Social Service Department for over 10 years. We're here this afternoon to talk upon the Child Justice Bill, and my part is just to inform you about the assessment and how it works. Simply, assessment is gathering of information to make an informed decision. When we gather information, the information is used for diversion. It is used for sentencing, and it is used for placing a child in an appropriate home, so that, because the child would have committed an offense, and this information that is gathered will help to determine what we do with this child. It is important that any child that is go before the Child Justice Bill, come before the Child Justice, is simply meaning that their assessment must be carried out. The purpose of an assessment is simply to assess whether a child is in need of care. Sometimes you'll find a child might be big in stature, and the child is determined not to give his age. With an assessment, we're able to estimate the child's age. As I said again, the information is used for diversion. Instead of criminalizing a child, the Child Justice Bill is here to give an alternative by simply diverting from the courts, if possible. If possible. This is why it's called diversion. The information also is there to inform the courts, inform the committee what is needed to assist the child. It is there also, if the child is need to be detained, that information will help to determine if the child needs to be detained. The assessment also help to gather information of previous conviction, pending charges, and if the child has been diverted before. Also, it helps to determine if a child is 10 years old and under, what do we do with this child? So by getting an assessment, we're able to make proper and informed decision. The duty of the assigned officer, that is myself and my colleague, Miss Nicole, who will come just after me to continue. We shall be responsible for the assessment, gathering of the information. We have a responsibility to inform the child of his rights. And also with those rights comes responsibility. Most times you find that we speak about the rights, but no responsibility. We are there also to inform them of their rights. The parent will inform the parent of the assessment, what the assessment is all about, what it's going to do. Okay? Who may attend to an assessment? The child. If the child is represented by an attorney could be present. The parents, the police officer who would have formally charged the child or apprehended the child, and any other officer who the police officer may see fit to summon. Also, assessment always looks for what is best to suit the child. We need to assess the child, assess the parents, assess the household. This is gathering of the information. Because sometimes what you may find that a parent and a child have one story. But if you check with the neighbor who is living there, who sees, who knows, you'll find that there's a disparity. So also neighbors need to be informed. One other thing is very key and important for the child is for the child to accept responsibility. Before a child could be gone to diversion, the child must accept that I have committed a crime, I have done this. In this way, remorse starts showing by accepting responsibility. Okay? And then, once you accept responsibility, we're able to recommend diversion or recommend detention, depends on the information, depends on the offense which is committed. Okay? As I said, consulting with persons outside of the home. When a report is completed, the assessment is completed, recommendations would be made. Myself and Nicole, we would make recommendations. Because once we have made that assessment and we gather that information, it's holistic. We look at the past of the child environment in which he grows up in. And this all inform our decision. So when we make a decision, we not just make a decision just like that. Okay? We make a decision based on the information that we have. Okay? This would help in our diversion. Okay? This would help in releasing the child into the care of another, or releasing the child into detention. As I said again, the child must accept responsibility. And if further assessment need, we will make that further assessment. The report, when it is finished, it must be passed on to the Director of Public Prosecution and also the Director of Social Services Department. When an offense is committed, the police has 24 hours in which to report the matter to Probation Department, where we will make the assessment. We have 72 hours in which to complete this report. So it's of paramount importance that we get this information as soon as possible, because that will help us to inform the necessary authorities, all right, as to what to do with the child. Now, I'll just pass on to Nicole, who will continue.
Good afternoon, everyone. Welcome. In the language of our ancestors, our Kalinago ancestors, I say mabrika to everyone and welcome to this public consultation. We're looking at the Child Justice Bill. I am Nicole Hickson, Senior Probation Officer within the Ministry of Health and Social Services. Thank you so much for taking the time to come and listen to our presentation this afternoon. Now, Part 4, Section 8 and 9 of the bill informs about the establishment of a residential facility, a secure residential facility, and also about the establishment of an assessment center. And it also tells us that this may be considered by the minister and in establishing and managing this facility. Now, there is a lot to think about when we think of this facility and what we need in Montserrat, whether or not we need a purpose-built facility, or we have a building already on island that could be converted to accommodate such type of facilities. And there has been some consideration in the past about the Kojahead police station, and I know one of my colleagues, Ms. Dyer, would have been involved with some of those conversations previously, looking at Kojahead Police Center in relation to whether it is a fit-for-purpose center that could be converted. Now, previously in the bill, it would have said that the minister shall, so that's been an adjustment. Instead of using the word shall, it now states may. So it's for the minister's consideration. Now, while we recognize that some young people commit crime, do commit crime and do fall foul of the law, what we've seen in Montserrat is that most of the young persons that come into conflict with the law isn't for serious offenses, and it's more for minor offenses. So it's very important that we look at diversion, and this is exactly the reason why the bill weighs heavily on diversion and looking at diversion interventions as opposed to going through a formal process and taking that young person to the courts and may lead to a conviction, which also has a sanction of time in prison. So it is very important that we look at diversion and how we can put measures in place to support the rehabilitation of our young offenders. And so my part this afternoon really is to talk about diversion, the initial assessment, and also to touch on restorative justice. Now, diversion. Firstly, let me just go back a bit and look at the initial inquiry. because diversion and the initial inquiry can come at any stage, but most of the time you have the initial inquiry first, which will lead into the diversion intervention. But you can have the initial inquiry still after you would have had measures in place for diversion. But the initial inquiry, what is this? This is an informal session that is held to look at the circumstances of the crime that has been committed and to look at what measures can be put in place to support that young person to keep them from going into a formal process, so a formal trial or a formal intervention. And this inquiry would include persons like the police, the probation officers, myself and Mr. Kelly, that is, social worker could be present, the child, the parent or responsible adult for that child, because at times what has previously happened in Montserrat is that a social worker would have been called whenever an appropriate adult was needed. But in this bill, the appropriate adult that it is talking about is not a social worker, and it is either a family member or someone in the community that will act on this child's behalf. So you can have that appropriate adult, you have the police officers, and you can have the Director of Public Prosecutions, DPP, present. Now, this initial inquiry should happen within 72 hours of apprehension of the child, and a decision has to be made of whether or not we are going to put in place measures for diversion or go to trial, start formal proceedings. Now, diversion. And this is a big part of the bill, and the most important aspect of all of this is because we're looking at how we put in place intervention and measures to support the offending behavior, that we can effectively rehabilitate that young person and get them to a place where they're not reoffending again. So this is a form of pretrial sentencing in which a child joins a rehabilitation program to help remedy the behavior leading to the original arrest. Now, Montserrat has an informal process already, and my colleague, Ms. Dyer, would have mentioned that when she said that myself and Mr. Kelly are already informally putting measures in place to divert young persons out of prison, to keep them out of prison. And so, which is why it's important that we really look at that measure. So we are doing that already informally, redirecting young persons away from the court and effectively out of prison. Now, the initial inquiry, which I spoke on earlier, previously in this presentation, and I mentioned before that diversion can happen before the initial inquiry or vice versa. So diversion can happen in two stages. It can happen in the pre-stage, so that's informal diversion. And this is an example. A police officer sees a young person committing a minor offense, for example, swearing. Now that officer can decide that he won't press charges against that young person, but what he will do is to give that young person a warning. Now, that young person gets a warning and the officer might ask them to write an apology letter. The young person does what is asked. That's done and dusted. That's the end of that. Now, the police officer may also report the crime and start a formal proceeding. Now, even at that stage, diversion is still used to keep that young person out of court and out of any other serious sanction. So a diversion intervention will be looked at this stage and sanctioned accordingly to address the offending behavior. Now, post-stage, which is stage 2, this is a formal diversion. So this is even after a formal procedure has commenced and the initial inquiry has happened to inform. Diversion is still looked at this point. And I am constantly saying this because diversion is a big part of the bill, because what the bill is trying to support is that we are not criminalizing our young people at an early age. We are not labeling them, giving them a label of criminals at a young age. And so we are trying to keep them out of this formal criminal process and put in place interventions that can support rehabilitation. Now, what are the objectives and why diversion? Now, diversion deals with the child or children outside of the formal process, out of the formal criminal justice system. And it's important, as I said before, that we aim to address the offending behavior at an early stage so we are not criminalizing. Now, diversion encourages the young person to be accountable for the harm they would have caused. So it's about putting interventions in place that can help that young person to be accountable for their actions. Diversion meets the particular need of the individual child. So it's looking at individual circumstances that would have led this child into conflict with the law, and whatever diversion interventions are used are tailored to meet the needs of that child. Now, diversion promotes reconciliation between the child and the person or community affected. So it helps the child to come to account with what they would have done that would have caused them to become foul of the law, and also to face the person or persons affected by what they would have done and to be accountable for it. Now, there is always criticism of interventions, and there is criticism of diversion. And some people might say that, why diversion? It's too lenient. That's not a punishment. We've heard that in the community before. Now, this person should have been sanctioned more severely. That punishment is not severe enough. But again, we are dealing with young children here, and here in Montserrat, what we are trying to do is to promote well-rounded, holistic individuals. So we want to address any negative behaviors by putting interventions in place that will support those behaviors, tailored intervention, one-to-one individual intervention. And the research have shown that diversion is more effective in reducing reoffending than conventional interventions. So why diversion? We're a small community here on Montserrat. Most people know each other, and we know our young people, where most of us do. We in probation and social work, we come into contact with these young persons all the time from day to day, so we know quite a lot of them. And just think about your child. If your child was to commit an offense, would you want your child to be criminalized? Just look at a 9-year-old, a 10-year-old. Would you want your child to be criminalized? Or would you want something to be done that will help your child to recognize that they would have done something wrong and have sanctions that are tailored to help them to develop and to grow into young adults without having a police record to follow them or a criminal conviction that will hinder their development as they proceed through life. We don't want to label our children with negative names, and the evidence demonstrates that human beings are influenced significantly by the way society labels them. If we label our young person as a thief, a criminal, etc., according to American sociologist Howard S. Becker, he states that individuals who are labeled as criminals by society may be more likely to engage in criminal activity. It's simply due to the social names and the way society labels them. So you see me as a thief, it becomes my way of being, and I start acting like it. Also, about the contagion effect. Now, a negative behavior is displayed by someone in prison, for example. So if we are criminalizing our young people at an early age and we are putting them into facilities with older persons who are more seasoned or hardened in that sense, and we are putting our young persons into those environments. Now they are looking at certain behaviors and they're adapting those behaviors for themselves, and it's becoming learned behavior. They're learning how to become a criminal. And this behavior is adopted by that young child. And so that young child now is at risk of continuing that offending behavior. And this leads us into restorative justice. So restorative justice schemes should be used to divert young people away from court and prison. It is adamant that we use restorative justice because it's a key element of any attempt to solve problems of youth and crime, and it's a balanced response to meet the needs of the victim and the offenders. And in probation, we are already doing quite a lot of work in relation to the restorative justice and diversion interventions. Just last week, I had a young man, and he was in court, and we have to put in place a lot of measures to address the offending behavior. And as a result of putting in some of those diversion measures, such as counseling, he was able to avoid prison. Now he's working through these diversion measures, counseling, and time in probation, and that is helping him to address his offending behavior, and it has kept him out of prison. Now, a massive part, again, I must reiterate, of diversion is the fact that we do not want to criminalize our young people on Montserrat. It's very important that we look at the cause of the behavior, whether it's to do with the environment the young person is attached to, whether poverty plays a part. There are many causes why young persons offend. So those have to be addressed, and those can be addressed by putting diversion measures in place and keeping our young persons out of formal criminal processes like the courts and prison. Thank you.
Hello, good afternoon. My name is Cora Galloway, and no, I am not a social worker, I am not a probation officer. I am an attorney, and I am involved with the Child Justice Bill because during my time at the Director of Public Prosecutions, I was involved in the stakeholder consultation. And even though I am now in private practice, I still maintain an interest in the area. And so I will be speaking to, and I don't know if I am going back or forward. This is technology. Yes, it doesn't want to work for me, it seems. But we've heard a lot of keywords. We've heard about initial assessment. We've heard about diversion. We've heard about so many wonderful words that we haven't been using before. And the Child Justice Bill, it is something new. It is something that seeks to formalize, and Nicole would have mentioned that some of the things that are intended under the bill, that they are already in existence here in Montserrat, and there is an intention to formalize the process. So now we're looking at the trial and sentencing, where we're now at court. For some reason, diversion has not worked. There are some youths, no matter what you try, the diversion may not be appropriate for them, or it might be that they have already been on diversion and it has not worked. And so they end up being in the court system. And so you're wondering, we're speaking all these wonderful things about diversion, but still they end up in court. It is a desire that even though a child may still be in court, that diversion would always be an option. Now, when they're at the initial inquiry and they're also during the assessment, they do not have to have legal representation. What the bill in its current state does is that when the matter gets before the court, if the child has not, or the youth has not secured legal representation, then the state is under an obligation to provide legal representation. And the bill actually lists 3 criteria. And so it's whether it is at the stage of plea and trial, or if it is at the stage where they have been detained with a view to going to a plea or for trial, and also if they're between 12 years and 14 years old. So that is the criteria. However, one of the current concerns is, what if you have some parents, that there are some parents who genuinely might not be able to afford legal representation? But what if there are those who think, okay, well, if we go to court, the state's going to provide legal representation anyway, so why do I need to bother? And so that is one of the concerns that's on the current bill. So what that triggers is sentencing. So let's say that they go to court and there are 2 options. They'll plead guilty or they'll plead not guilty. And we are going on the premise that there is a conviction. Even at this stage, following a criminal trial, diversion is still an option. So although they may be convicted, it is not automatically that a prison sentence would be imposed. So the court has to decide at that stage what would be the appropriate sentence for the child as it is set up under the legislation. And see, it doesn't want to work for me. It worked very well for the others. And so in terms of considering sentencing, there are criterias, or there is a criteria which the court has to consider. The court also has to take into consideration the age of the child. The court also has to consider the family situation, remember that Mr. Kelly spoke about having to do an assessment, because remember, some of the options include whether they go into a facility, and Nicole would have touched on the fact that at the moment in Montserrat, we do not have such a facility. And unfortunately, in circumstances where the youths, juveniles, they have to be incarcerated, unfortunately, they go to prison. There is a juvenile wing there, but that is not ideal because you have adults that are also housed in that same institution, and there will be some interaction even though there is a juvenile wing, and bearing in mind that it is a desire not to criminalize the youth, and so you want them in an environment that is different, and so that is why the court also has to consider whether there's any treatment, whether the child may have, health issues, because prison will always be a last resort. Other options have to be considered, and such options will include whatever is put forward in perhaps a pre-sentence report, because remember, when the probation officers provide their pre-sentence reports, they might provide recommendations. They might provide that there is a responsible adult or someone who might be willing to supervise the child if it is that the child is in an environment in which the behavior is learned behavior, and so the child needs to be removed from that environment to assist them in the process of being rehabilitated and learning the consequences of the actions and trying to do better. There's also correctional services and community-based sentence. So that may be if they decide, the court may decide, okay, well, I need you once a week that you would go and do some sort of community service. That could be some form of correction that the court considers. Compulsory residence in a correctional facility, when we get one, okay? That is an option for the court to consider. In addition, let's say the court decides that, okay, what has happened meets the threshold of a custodial sentence. It is possible for the sentence to be suspended subject to conditions. Now, before the child is detained in prison, so we're looking at the instance where the court has considered all these options and is still not stacking up. It's like, okay, well, prison seems to be the option. There is still other considerations that the court must take into account. Paramount throughout all of the bill is the best interest of the child. So even during the sentencing process, the court has to consider what is the best interest of the child. I would have mentioned earlier about the child's state of health. What if you have someone who is asthmatic? What if you have someone who needs regular attention? If they are incarcerated, will they get this child get the necessary attention that the child needs? Is there an alternative? Because remember, it is not about punishment. It is about rehabilitation, okay? The danger that the child may pose to him or herself and the public is something which also needs to be taken into consideration. The risk of the child absconding from a placement. So the court might be considering, okay, if I was to put the child in a placement, will they abscond? So is it better for them to be placed in prison? Any impediments, because remember, there are times that perhaps the trial has not concluded, but for whatever reason, the child is in custody. And so the court also has to consider whether if the child is placed in custody, that would present a problem or an issue in terms of the child meeting with their defense attorney, being able to put things together for their case. The seriousness of the offense, that would also play a key part. So whether it is a summary offense, which is dealt with by the magistrate's court, or whether it is an indictable offense, which will be dealt with by the High Court. In addition, again, if the child is in custody and the matter is ongoing, the court also has to consider the period of time which the child might be held in detention. If it's going to be a short time, would that justify keeping them? If it's going to be a longer time, are there concerns, are there protocols, are there things which must be put in place? As I keep reiterating, the purpose of sentencing is about rehabilitation, reintegration, and to allow the child time to reflect on their actions and the consequences of their actions. Okay, so that is key throughout the bill, rehabilitation. How could we get this child back into society without the stigma being attached to them of having committed an offense? And bearing in mind that they're not even 18 as yet. We would have spoken about the whole thing about age, 12 to 14. Imagine a young child that age having a conviction. That would be the last thing that you would want to happen. And what if they then get a conviction and they say, oh, well, and so they just keep going and going. And so you've planted a seed, if you like, for a career criminal. And so in terms of getting them to understand what they're doing, the consequences, rehabilitation, it is hoped that they will not offend in their youth and later on in life. Now, when the court is offering sentencing, there are certain rules that the court must consider. The child's age, their circumstances, their development. And this has to happen prior to sentencing. The court cannot impose a community order under supervision and a warrant of detention for more than 3 years. So there is, I'll say that again. The court cannot impose community services under supervision and a warrant of detention if the sentencing is detention. Okay? The court cannot give a sentence to a child with a residential requirement. Could you imagine if they had just stayed locked in all day? So, you're taking into account the fact that these are children, these are youngsters, and so the sentence which is applied, it has to be reasonable. The court can also assess an individual's fitness, and based on what Mr. Kelly would have said about the assessment, the court would have all this information available to them. So if part of the sentencing they're deciding that they're going to place the child with an individual who would probably be a mentor, a supervisor, the court would have to satisfy itself that that individual will be able to assist with the rehabilitation and the reintegration of the child. There's also what's called family group conference. And as part of that is where the victim would meet, the family. So the court could also refer the child to the family group conference. And as part of that, it is hoped that, in the discussion with the victim and the family, that the child would actually understand their actions, their consequences. And if you like, it sort of gives closure to the victim and their family. And it's a way of, Montserrat is a small community. And it's a way of everybody coming together to assist the child. There is a cap of 3 years. I think I was premature when I said that earlier. But there is a cap of 3 years for correctional supervision. And if the child is over the age of 14, or the offense is a serious offense, the child cannot be sentenced for more than 3 years. So there's still safeguards which the bill as proposed has for these children, for these youths. And if the court feels that the child could be reintegrated into the community, they could still be given a chance by the court suspending sentencing. So if you like, it's a trial run. I don't know if that would be the way to put it, in terms of, okay, we've gone through, a sentence might be appropriate, but let's see, let's give him or her a chance and see how they will do in the community. And what is important to note is that fines are not encouraged, because if you fine a child's not working. So it's the parents who would have to pay. And it would be as if it's a punishment to the parent. However, if there is compensation to pay to the victim, then the parent may have to pay that compensation. So once the child is not fined as it relates to the offense, in terms of compensation, the parent would have to be responsible for that compensation. So I just want to remind you that although there is a court process, like all things, provisions have to be made. But the ideal is not for a child to be convicted, for a child to have a criminal record, but the focus is more on diversion, more on having the child being reintegrated. It's all about restorative justice. And so, with all this in mind, if there are any comments or questions which you may have, please feel free to do so.
Thank you very, very much to my colleagues for their presentations. Now we'll give you an opportunity to ask questions. If you do want to ask a question, we'd ask if you can go to the mic that's just in the middle of the hallway there, and we'll seek to respond as appropriate.
Thank you. Is the microphone on, please? On? Yeah, okay. Margaret Ainsworth from Montserrat Children's Society. Children's Society, as Miss Dyer knows very well, is the leading charity in Montserrat which supports vulnerable children. In fact, it's the only NGO that exists purely to support vulnerable children. And I would say that children facing coming into contact with the legal system are definitely vulnerable. Unfortunately, we've come rather late to this party, because we didn't actually know, as the Children's Society, that there was a consultation happening until Saturday, I think it was. And so I haven't had the opportunity to call a meeting of the Executive Committee, and I haven't had the opportunity to consult at all with our database of members and friends and supporters, which is about 200 people, both in Montserrat and overseas, who I'm sure would be able to make a very useful contribution to this debate. So I do have some comments, but they're certainly not comprehensive. So firstly, the draft bill mentions the age of criminal responsibility, which in Montserrat is 10 years old, and the draft bill appears to continue with 10 years old.
although there's some question about it moving to 12 years old. And I noticed that you did make some comparisons with some other Caribbean states. We feel that if Montserrat is proposing to adopt new legislation, I don't know whether the legislation in other Caribbean states is up to date or whether it's quite elderly. But it would be, I'd like to see Montserrat reflecting best practice on the world stage rather than average practice on the Caribbean stage. Now, the draft mentions 2 ages. Now, the international standard for the age of criminal responsibilities, I understand, is 14. I'm not an expert in this. That is what I have been told and what I've read. I think that from what I understand in the draft bill, there is a question about children of up to 14 being assessed to see whether they have an understanding of what they have done, and if they don't, then they would not be considered to be able to accept that responsibility. Now, my question on that particular issue would be, how would you make a decision about a child between the ages of 10 or 14 to understand whether or not they are able to understand what it is they have done, and not just to say, yes, I did steal that goat, or yes, I did hit that person over the head, but to also understand the consequences to themselves of potentially being in court, to potentially being punished, and the consequences possibly to the person that is the victim. And can you say, and I understand that from the draft bill, I understand you have to make major decisions within 72 hours. Who makes those decisions? What are their qualifications? How do we know that those decisions are valid? Is it a psychologist who makes those decisions? How is it come about where you decide whether a child of 10 understands what they have done or whether it should be a child of 14? I think that's a big area which needs some work on it, to be honest. The second query that I have, and this has been referred to by the speakers, and obviously, you know, you're well aware of the issue, but the draft bill makes reference to some bodies like the Child Justice Committee, for instance, and some facilities such as assessment centres, secure residential facilities, which, as you know, the speakers have already accepted, we don't have in Montserrat. And we are talking about very, very small numbers of children, potentially. I mean, looking at the figures that were available from, I think it was 10, 11, 12, 13, and 14, one year there weren't any children who faced the court at all, and in other years it was 4 or 5. So we're talking about very small numbers, and I noticed that the slide that talked about secure facilities seemed to be a bit ambiguous. It talked about the minister may make a decision to provide such facilities. If I've misunderstood that, I apologise, but I would say that if a child is to be incarcerated in an adult prison because we don't have any other facilities, that, I'm afraid I would consider that to be a criminal offence. I don't think children should ever, under any circumstances, be put in that position. And when you are making a law that allows for, or in fact requires alternatives to that, and then you can't provide the alternatives, then the law is not actually of a great deal of use, I'm sorry. But possibly you can answer all of that positively, I hope so anyway. Another query that I have is, this hasn't been clarified by I listened to the radio, I've read through these slides, and I've read the bill, and I'm still not clear. Is there a requirement for a child to be accompanied by either a parent or a responsible adult at all times? Because I would suggest that there should be, that a child who has been arrested by a policeman is taken to the police station, the first thing that should happen is that the parent is notified, or if the parent is not available or not suitable to be notified, then a responsible adult, and they should be there immediately, and the child should not be put in a cell and left on their own. And another thing that I didn't hear, but maybe it's there somewhere, is there any provision in the draft bill for translation services to be made available either to children or parents where English is not their first language? We have a number of immigrant communities in Montserrat now, and we do have people in Montserrat whose English is poor or almost non-existent in some cases. And I don't hear any mention of any facilities being considered for that. Okay, the next question is about children with disabilities, and this was touched on, but I would particularly suggest, what about children who have behavioural problems, such as autism, ADHD, which would, or otherwise have a physical disability which would require them to be physically dealt with in a different way. So, I mean, children with behavioural issues which could result in offending are actually in the main undiagnosed in Montserrat as it stands at the moment, and are quite likely to be treated as naughty children just in their normal behaviour, and I don't know how they would be treated if they broke the law, because they're not diagnosed as autistic, they're not diagnosed as ADHD or other conditions, and how would those sort of issues be dealt with is the question. I think you've sort of answered legal representation questions. I mean, as I understand it, a child would be entitled to legal representation, but I wasn't quite clear if that would have to be paid for by parents or not. And the second to that is, if there is an issue about the parent, for example, about a child being returned to a parent for some reason, or not returned to a parent for some reason, what about the parent's right to legal representation? In that instance, if the parent wanted to say, actually, no, I am a good parent and there is a very good reason why you should return my child to me, who is available to back them up from the legal profession, and at what cost? The other points I'd like to make really are sort of a little bit outside the bill, a little bit. Question, does this bill outlaw corporal punishment? Corporal punishment is a violation of the United Nations CRC. Is it, and I know that the United Nations have asked Montserrat to remove it from the statutes. It is quite difficult to see how it fits in with a modern justice system. I don't imagine that it's actually used at any time, but if it is still there on the statute, then perhaps it's time it was not. And the other point is, we welcome this bill. This is part of meeting the United Nations Charter and all things that are part of that have been identified as being out of date or lacking in Montserrat. It's all important stuff, and there's been an enormous amount of work gone into this bill. But we'd also like to see the government of Montserrat making progress in other areas, in particular child safeguarding. If the 2016 UNICEF review actually strongly recommended the appointment of a children's commissioner. Now, that isn't a role that really fits in with this bill, but in terms of child safeguarding, I would suggest that that is actually a very important role, in that it provides children or parents or social workers or teachers or health professionals with a direct point of contact in confidence if they have any issues about the safety of a child, or whether that child is being abused, whether that child is being neglected or ill-treated or in danger in any way. And a children's commissioner can hear in confidence about any issues and make a decision about what needs to be done to resolve that situation or help that child. So, as I say, I'm sorry it isn't directly part of tonight's conversation, but take any opportunity, that's me. Oh, and just one final thing, and I don't know whether this was covered in your speech or not. About parents paying compensation to victims, I think you did speak about this, I'm sorry. But it was just, I sort of understand what you mean, that if there's a victim and they've had a financial loss, then they would be looking for compensation. But if paying that compensation, if the parents paying that compensation damages the parents' relationship with the child, because the parents become unhappy with the child because you've made me have to go into debt to pay this compensation, that actually is not boding well for the future relationship of that parent and that child. So I don't know the answer to that, that's for the professionals, but I'm just raising it as something that occurs to me. And finally, I have to say, I've not had the opportunity to consult with the Children's Society Executive Committee or the rest of our members, because we just didn't know anything about this until Saturday morning. So I cannot say that the comments that I've made and the questions that I've asked totally represent the Children's Society view. Thank you.
Thank you. You said quite a mouthful. Certainly with the legal representation, it could be at the initial inquiry, it could be at the assessment, and you have the court proceedings. At the initial inquiry and the assessment, it is optional. At the court proceedings, there's an expectation that there will be legal representation, and if the parent cannot afford it, it would be at the state's expense as currently drafted under the bill. It's important to note that because it's a child, it will be in camera. It would be a special sitting, like a juvenile court. So what would happen is that although we do not have a juvenile court, what would happen is it would be constructed in that way. So when I say that, it would have the, if you like, under the legislation, we do have the provisions for the sitting of a juvenile court. So although you may be saying that we do not have a juvenile court, it's just a magistrate's court, it would be sitting, if you like, as a juvenile court. Okay, I know those who are viewing, they can't see you shaking your head and mouthing at me. So yes, so I hear what you're saying, but that is actually the process that is intended. As it relates to the responsible adult, the expectation is that at every point in time that there would be an appropriate adult with the child. So if it is that the child is taken into custody, there is an expectation that there would be an appropriate adult that's present with the child. I wouldn't say that, because you referred to the worldwide scale and the Caribbean scale. I think to some extent in some Caribbean countries, they're actually further ahead, because I believe in the UK, the age of criminal responsibility is still 10. And so we are actually not divergent, and that's part of what the consultation is about in terms of whether the age may change and that sort of thing, because there are some Caribbean countries, as Ms. Dyer would have indicated, where the age is different. There are some Caribbean countries where it's 12, and there are others where it's 14, it's 16, so there's a difference across the Commonwealth. I'm trying to think if there was anything else that I needed to cover. Okay, the other thing, yes, it was about the corporal punishment. And I believe in the legislation that it states that when a sentence has been made, that life imprisonment or any form of corporal punishment shall not be imposed upon the child. So whilst it might not go as far as you expect it to, it still covers it, that corporal punishment is something that should not be imposed upon the child. So I believe that the others will come and touch on the other issues that you raised.
Thank you very much, Cora. Thank you very much for your questions and your comments. Really helpful. Can I just add to the point about age of criminal responsibility? In 4 of the islands that I mentioned earlier, they have in fact, since their implementation or consideration of a new bill, they've gone up to the age of 12, and those are Antigua and Barbuda, Grenada, St. Kitts and Nevis, and St. Vincent and the Grenadines. So the ages that they were at, in considering the model bill, they've increased their age range to 12. As was said, in England, it's 10. Here in Montserrat, there is a feel about trying to stay at 10, but you know, that's what the consultation's about. It's about our public telling us we'd like some consideration about that being increased, or, you know, hopefully not decreased, but, you know, increased. Just to...
Can I just come back on you on that one, really? I mean, I think if the age were to be increased to 14, in the first place, it reduces actually the number of children who actually come into contact with this bill and the system, because you know, more children would actually be considered to be below the age of criminal responsibility. And so we've already said that this affects a very small number of children anyway. And if the number of children is actually reduced, it might not affect any at all. And it might mean that this process, whilst it remains there to be used if it needed to be used, and things like secure residential facilities and so on, actually don't need to be put into place. And also, I mean, I'm not a child professional, but I've given birth to a few, and I've had a lot of dealings with children, and you know, a child under the age of 14, the very thought of that child coming into the police system, coming into the probation system, coming into the court system. I appreciate absolutely that the main thrust of this bill is on diversion, and hopefully that is how it will work. But if it isn't, if diversion is not occurring, and the age is 11 or 12 or 13, I actually personally feel horrified at the thought of a child of that age coming before the courts or coming into the system at all.
Yeah.
And I can't imagine how it could do them any good, but I can certainly imagine how it could do them a lot of harm. So that's...
Thank you. I think you're echoing the sentiments of the bill, that it's about keeping children away from formal court proceedings. We know children will make mistakes. We know that they'll do things that are inappropriate, and the best endeavours that the various stakeholders will put in place is to try to find solutions that mean that they don't have to go through the court proceedings. And as I said before, I think that in Montserrat we're already informally pushing children away from the court proceedings. So it's just a matter of having a formal document that helps us to consistently do what we already do. Just to make the point about equality of opportunity for children who might have disabilities, children who might have English as a second language, children who might have behavioural needs, those needs will hopefully be met through the systems that we're trying to develop. I take your point about not having an educational psychologist. We did have one, but no longer. But I would hope that other systems would be put in place for psychologist input. We have got a clinical psychologist, but your reference was specifically to a child psychologist, and that's something that we might need to be thinking about as part of this bill. I like the idea that you shared about the Children's Commissioner. I'm mindful in the UK that there's one for the whole of England, I believe it is, and it'll be interesting to see what the thoughts are around how we can get one either for Montserrat or one that can cover, you know, the British Overseas Territories. Yeah. And I can't overemphasize the fact that what we're trying to do is to move children away from formal court proceedings. We've talked a lot today about diversion, reintegration, rehabilitation. Those are the words that feature through the bill, and it will be important and incumbent on the people that will be working in that system to actualize those comments. You know, they're not just there for the sake of being there. They actually want us to be actively working on these areas. So I hope that we've kind of covered most of the area. You talked about the parents' role. As I mentioned in my presentation a bit earlier, the parents have the right to assist their children. So we have to make sure at the point where a child is apprehended that the police are quickly identifying who's the parents, where are they, we need to get them here. If they can't find that person, that's when an appropriate adult has to kick in, the next best option. And with all of that, the whole point for me here in Montserrat, I think it's quite important to recognise that yes, it is a very small community, and you will always find that person who has the best interest of that particular child at heart. They might not be an uncle, a grandfather or whatever. They could actually be a community friend, a church member, but we'll always find that one person who says, oh, I know that young person. Yeah, I think I can do something with that person, so I'll be here until the parent can show up. So we have an obligation to make sure the parent, appropriate adult, are in at a very early stage, and they will be attending all of those forums we heard about, the initial inquiry, family group conference, the assessment. All of those forums, the parent or the appropriate adult will be involved. I think I've covered most of the queries that you had raised. Yeah, I did say about English as a second language. We would endeavour to use interpreters if it becomes necessary. So just to recognise that. Okay, so I know you covered quite a bit of ground. I wondered if there was anything else you wanted to share that we haven't emphasised, we need to emphasise, it might be missing, whatever, what your fears about the bill. Is there anything else you would like to add?
No, I think I understand that there probably does have to be a bill like this. I would repeat and repeat and repeat that I think the older the child is before they have to take responsibility, the better for the child. And the less children that are actually brought into conflict, legal conflict in this way, the better. And I mean, as Ms. Dyer will know, as a children's society, we have helped in numerous occasions when a child has been either heading for trouble or has been having difficulties in the family, and we have put in various financial help and supports in one way or another. It might have been that the child has been missing school. We've helped social services to put in extra tuition for that child, but the extra tuition has been carried out by someone who has the child's best interest at heart and is observing the child in the family situation and supporting the child, not just teaching them maths and English, but actually acting as a mentor and a support for that child. And there are numerous situations, that's just one example, numerous situations when we have worked with social services and hopefully done something to prevent children getting into legal trouble. And the more that can be done to do that, then absolutely the better.
Thank you very much. One of the things that we have to develop as part of this bill is clear, structured diversion programs. So I'm clear in my opinion that clearly the Children's Society will be an avenue where we'll be looking for diversion options through your organisation. One of the things that I'm kind of mindful of is that we're probably coming to the end of our time in terms of live streaming, but what I wanted to say to the listening public is that we are holding further consultation sessions both Wednesday the 8th of December at the Davy Hill Wesleyan Holiness Church between 4:30 and 6:30, and then on Thursday the 9th of December we'll be at the Lookout Community Centre between 4:30 and 6:30. We know that not everyone will be able to come out to those events. However, we have an alternative if you wanted to share your views from this afternoon's session, or indeed the session that we did on Monday morning on the radio. If you wanted to convey your views, you can either contact us by phone on 491-3895 or 495-3895. Or you can send an email to socserv@gov.ms. I'll repeat that, socserv@gov.ms. And you can send your comments in however much detail or how many emails you'd like to send, and we'll certainly take account of them when they come in. You could also find us on the government website. If you go on to the Government Information Unit website and look for social services, there you'll find an opportunity where you can convey any views that you have that you'd like to share with us, and those will be collated. What we're hoping is that throughout the rest of this month that we'll still be able to receive your views, your thoughts, your comments, and we'll be able to integrate that into our thinking in the early year of 2022. So at this stage, I wonder if my colleagues have any parting words they'd like to share before we conclude? Okay, just by way of ending today's session.
Personally, it's a draft bill, and only by consultation with the public can it be improved, as our audience this afternoon have posed very good questions and needed some answers. This is really what we want, so that when the bill, before the bill is passed, that all these comments can be looked at and see where we can improve on the bill. Because right now it's just a draft and we are having consultation. So I'm just pleading to the other communities that members should come out, and wherever there is a question that needs answering, to ask the question, and I will try as much as possible to answer your question as we go forward. It is for our children, and as I always say, it takes a village to raise a child. So all the questions, bring them, we'll try and answer them.
As my colleague, Mr. Kelly, would have stated, our children are important to us. They are our resources. They are the future of Montserrat. So this is why this bill is so important, because it's looking at our children and putting our children at the forefront of what we are trying to do here. We do not want to criminalize our young people at a young age. We do not want to imprison our young people. And so that is why we are looking at putting in place diversion measures formally. As we would have stated earlier, we are doing it informally, and now we have a chance to formally put things in place to protect our children and to help them to put interventions in place that will address whatever the underlying causes are that would have caused them to come afraid of the law. Because we know we are dealing with children here, and they will make mistakes, but we are giving them an opportunity to have wholesome lives ahead of themselves without having a criminal record to follow them through. We know how detrimental that could be if we have a criminal record, especially in today's society. It hinders certain jobs and certain aspects of your development. So come on out to the public consultations, and we'd love to hear your views about what you think about the bill, what should be included, what we can make adjustments to. As the audience would have stated earlier, that they have a lot of views in relation to the bill, and so we welcome those views. So continue to have your say as the week continues, and we wish you a wonderful good night. Thank you.
The thing about going last is everybody has said what, the good stuff. But what I would encourage you most certainly is to come out. Because too often when the law is passed, the ink is dry, we say, well, we wish that this was in the act. Oh, what about this? Why is that not there? But through this consultation, you have an opportunity to comment on the bill. I know when I came and I commented on the comments which were made by the Children's Society, I said that's quite a mouthful. It is better to say quite a mouthful, get your views out there, improve the bill, have an impact, because the children are Montserrat's future. And what the bill is encouraging is where some children have lost their way, rather than turning them into criminals. Or, we're not necessarily turning them into criminals, but that is what happened when somebody has a conviction sheet, that there is an automatic, the word escapes me, there's an automatic stigma attached to them. And so through the restorative justice, through diversion, through all these wonderful things that the bill proposes, the intention that our children will be rehabilitated, they will be reintegrated, and that as they make their mistakes, that they are given the tools in which to deal with them, rather than just slapping them in prison and having that stigma attached to them. So have a wonderful night. Thank you for joining us, and I do invite you to tell a friend about the consultation so that they too may have their views heard.
Okay, thank you, thank you, thank you. Thank you for listening to this afternoon's session. Thank you for the contributors, and also thank you for the questions that were posed to the panel. The only thing I would like to add is that our children are indeed our future. How we treat them when they make errors of judgment is quite important. It could either dictate that their future goes down a certain path or not. So it is so important that all of the key people in children's lives are working together, and in that I include the child themselves, the parent, the appropriate adult, and indeed the community that can help to steer children away from the formal courts within Montserrat. Thank you very, very much for being with us this afternoon, and I wish you not only a pleasant evening, but also season's greetings. Take care. Bye-bye.